Section 21 of CPC deal with pecuniary and territory jurisdiction. Objection as to place of suing shall be allowed in the court of first instance is essential at Section 21. Which one of the following section of CPC 1908 deals with the essence that court that objection as to local and precarious jurisdiction shall be raised at the first opportunity. Section 21. Objection to take place in the suing can be allowed to be taken in only at the first opportunity in the trial court. Which section of CPC provide that the objection as to territory and pecuniary jurisdiction must be raised at the first opportunity. Section 21. Under which provision of CPC in a suit set aside a decree on the ground of lack of territorial jurisdiction is barred. Section 21A. Under Code of Civil Procedure 1908, objection as to jurisdiction as the place of suing shall not be allowed by an appellate or divisional court unless such objection was taken when the condition of the A, B, C is fulfilled. What? In the court of first instance, at the earliest possible opportunity, at there has been consequent failure of justice. Objection to the territorial jurisdiction of the court can be allowed if it is raised by at the earliest possible opportunity and before the issue are settled. Objection as to the place of suing shall be taken by the court of the first instance is the essence of the section 21 of the Code of Civil Procedure 1908. General power to transfer the suit under section 24 has been granted to 24 High Court and District Court. General power of the transfer of suit under section 24 lies with High Court and District Court, under which provision of CPC High Court may transfer the case. Section 24. Which one of the following order is not appealable under the Code of Civil Procedure? An order under section 24 is not appealable under which of the following provision of CPC Supreme Court can transfer a case. Section 25. Under section 25 of the CPC, which of the following power of the Supreme Court to transfer suit? By whom can transfer of a suit or proceeding from one state to another state is ordered? Supreme Court. The provision for the institution of suit is given in which of the following section? Section 26. In every plaint under section 26 CPC, facts should be proved by on affidavit. In which section of CPC provide institution of suit? Section 26. Under section 26 of CPC, every plaint fact should be proved by on affidavit. A person against whom summons has been issued may be compelled under section 32 of CPC attained by issue of warrant, attachment and sale of property, imposing a fine, order him to furnish a security for his appearance. Under section 32 of CPC, to compel the attendance of person whom summon has been issued under section 30, court has empowered to issue a warrant of his arrest, attach and sell his property, impose a fine not exceeding 5,000 rupees. Under section 32, maximum fine can be imposed by the court while compelling the attendance of a person who the summon has been issued under section 30 is 5,000 rupees. Where a decree is silent regard to the future interest, the future interest shall be deemed to have been refused when separate suit shall not lie. Under Section 34 of CPC, court can award interest at the date and decree at the time of the payment of such either date the court think fit. The rate of interest shall not exceed by 6%. Where the decree is silent as regard to the future interest, further interest shall be deemed to have been refused and separate suit shall not lie. Provision of the interest of CPC has been made under Section 34. Under civil proceeding where the decree is silent as regard to the future interest, further interest shall be deemed to have been refused in a separate suit shall not lie true. The in a case of a decree of the payment of a money, the court can order an interest rate of the 6% per annum. Compensatory cost under Section 35A of the CPC imposed extend to 3,000 rupees. What is the maximum amount of the compensatory cost that can be awarded under Section 35A 2 of the Code of Civil Procedure? 3,000 rupees. Under the Code of Civil Procedure 1908, for the first time, the provision of compensatory court respect to the false and vexatious claim or defense has been made under Section 35A of the CPC. In the CPC, Section 35A added to the amendment of 1970 as providing cost for causing delay, where the liability in the relation to the sum adjudging has not been arisen out of the commercial transaction. The maximum yearly rate of interest awarded under Section 34A of the CPC from the date of decree of payment of money payment is not more than 6%. Compensatory cost in respect of false and vexatious claim or defense can be awarded to 3,000 rupees. Compensatory cost can be imposed to if the claim of defense is false, vexatious to the subsequent disallow or withdrawn, if the objection to the false and vexatious and cost imposed under Section 35B of CPC shall not be included in the cost awarded in the decree passed in the suit, shall, if not paid, is executable against the person on whom the cost have been imposed. Which one of the following in the order of appealable under Section 35A? Any amount which the court will order to pay the compensatory court in respect of false and vexatious claim defense shall not be exceed the amount of 3,000 rupee or the amount with the pecuniary jurisdiction whichever is the less. The maximum amount of which court may order for the payment of compensatory cost in the case of false and vexatious claim of the defense under CPC 1908 is 3,000 rupees. Every suit shall be instituted in the court of lowest grade competent to try it, territorial jurisdiction and pecuniary jurisdiction. Jurisdiction of the court is decided by subject matter of dispute, pecuniary value of the suit, place where dispute is arises. The principle of the constructive res judicata was explained by Honorable Supreme Court in the case of State of UP versus Nawab Hussain, in which condition the officer in charge of the prison may refuse to produce a prisoner for the evidence despite of the court order, where the medical officer has certified the prisoner is unfit to be removed by the reason of sickness. In the reference of district court, which one of the following statement is not correct? It cannot retransfer any suit, appeal, or any proceeding to court from which it is withdrawn. Is incorrect. Which one is correct? It can transfer any suit, appeal, other proceeding pending before it for the trial of any court subordinate to it competent to try it and dispose the same. It can withdraw any suit and appeal other proceeding pending in any court subordinated to it. It can try, dispose of the suit, appeal, or other proceeding withdrawn from the court and subordinated. It may transfer the same trial and dispose of the some other court subordinate to it and competent to try it the same. Which one of the following is not a suit relating to immovable property? Suit for rent in respect of immovable property is not a suit relating to immovable property. Which one is the suit relating to immovable property? Suit for the recovery of immovable property, suit for the partition of immovable property, suit for the redemption of the mortgage property. Which one of the following is not a suit of civil nature and res judicata? A suit against the deprivation from the attending the social function. Which one of the following is a not case of the res judicata? Chajju Ram versus Nikki is not a case on the res judicata. Which one is the case on res judicata? Duchess of Kingston case, Munni Bibi versus Tilokinath, Badham Pistoniji Keriwala versus Union of India. Doctrine of res judicata is not applicable to the case of the following writ habeas corpus. The court may compel the attendance of a person to whom summon has been issued under section 32 and for the purpose may impose fine which not exceeds to the 5,000 rupees.